Welcome everybody to our 26th webinar. Today's topic is going to be 10 deadly estate practice sins, and we are joined here with Mr. Jeffrey Marsocci.
All right. Well, welcome everybody. Thanks for being here. As is often the case, I may end up with a bunch of clients in the morning and talk myself out. So it's a good thing we've got this video to do the main presentation. So we're going to go ahead and get that started, but I am definitely here for questions and would really love to hear from you, hear what questions you've got, what contributions you have, especially around this area where we can, as a network, share information among professionals just to see what's working for us and what isn't. So I will go ahead and get started, and I'll be hanging around for those questions. Thank you. What should you never, ever, ever do in an estate planning practice if you want to have a viable business that meets the needs of your clients? What policies need to be in place to eliminate time wasters? How do you screen in good clients but keep the bad ones out? And what's the one big thing that can turn a prospective client into a walkout about half of the time? I'm Jeffrey G. Marsocci, an attorney, author, and member of the Estate Planning Sources Attorney Council, known as the Plain English Attorney. And I will review my list of 10 deadly sins in an estate practice and client process that saves me from wasted time, colossal frustration, while helping me get the clients I enjoy working with, all while providing my clients an exceptional experience and top-notch estate plans. This presentation is being created for a webinar for the Estate Planning Source to air on June 17th, 2025 at 11 a.m. Mountain Time, and that's 1 p.m. Eastern Time. For my clients, audience, and the general public, I'm going to give you 3 of these 10 deadly sins, but you have to go to the Estate Planning Source's YouTube channel to watch it live or get the replay after June 17th. Don't worry, I'll make sure that the one big thing is included as part of the 3 being released early on my channel. So the 10 deadly estate practice sins. What are we never, ever, ever going to do? We're never not going to have an estate planning process, not have our staff well-versed on it. And also, if there are other professionals involved in the process, they need to also be on board and understand it, and maybe even we're negotiating it. As an example, with the estate planning source, there's one particular advisor. We do a lot of work together, and for them, we know that there's a process. Here's what happens first. Here's what happens second. Here's what happens third, and here's who's assigned to each of these tasks. What happens in between each of these meetings with the client, which may be ones that I do or ones that they do. All of this is laid out, and we all know what page we're on, and our staffs understand what's going on. I've also got some written procedures on how to do this that we work together on. So there may be a different process for what you want to do. If you're an estate planner, whether it's a law firm or an advisor or an accountant or some other type of professional, you just need to make sure that every step of that process is laid out, becomes a standard operating procedure. That's just the big thing. So what's the second deadly estate practice sin? Not documenting the client process and progress in a CRM and in your files. So this is making sure that every time that there is a specific action, either you're dropping in a template like we do in the trust planning process, so we can check the box when things happen and it's automatically recorded. Client calls for a meeting, we log that call that came in. Oh, there's an appointment set in, it goes into the system, so it's not just written down on a piece of paper. It's all done electronically. It's all kept in the system. So all those notes are always there. This becomes important if there's any kind of dispute. So I'm just going to give you a quick story. I did a plan for a husband and wife many years ago. I mean, more than 20 years ago. And so they wanted to update it, or at least had questions about it. And husband and wife came in And the husband, I want my daughter to be the person who's in charge, and I want this to happen, and this needs to happen in terms of distributing the assets. And the wife's like, no, 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 no. She completely disagreed. They couldn't get on the same page. So it's like, look, you need to figure this out, come to some sort of compromise. But here's the big thing that I noted in the CRM at the time. He absolutely positively refused to fill out the confidential financial analysis form that we typically ask our clients to do so that we can walk through and making sure that their trust is properly funded. Didn't want to do it, absolutely refused. I'm not going to talk about it. Okay, I made the note in the CRM. All right. A couple years later, mom's passed on. Dad comes in. I want these changes. I want it done now. So he lived longer. He got to do what he wanted to do. All right. Got changed, got updated. Once again, didn't want to talk about the trust funding, didn't want to disclose any of his assets. It was none of my damn business. Okay, fine. I came very close to not even taking the case just because he was so disagreeable. And it turned out the daughter was pretty much the same way. And so went through, made the changes, noted in the CRM, refuses to talk about any of the assets, so we can't talk about trust funding. Year later, dad passes on, daughter's yelling and screaming that we paid all this money for this trust, and it's all. I talked with my broker, and he said that this account's going into probate. How dare you? This has got to be malpractice. We're going to get you all on a Zoom, and we're going to find out what happened here. Where did you fall down, attorney? I was able to pull up that CRM. Here's what happened. Here's what happened. Here's what happened. The advisor was ready to be like, shouldn't you have informed the financial advisor? Don't you work with these financial advisors? And then I'm like, look, here are my notes. I'll send you copies of it. He refused to talk about anything. Now, if I hadn't put that into the system, it might have been a lawsuit, and it could have been a complaint with the state bar because the daughter was just that livid. But look, I had all this documented, dated proof in the CRM. So it's important to make sure that it is documented. All right, so let me talk just a little bit about the client process, and I'm going to pull it up, and I'm going to keep this super quick. In the estate planning process, I realized that there's an awful lot of information. There's homework that has to be done on the part of the clients. And the way a lot of attorneys do things, it's like, okay, you gave me the information. I'm going to put together the documents and I'm going to send it to you. Here's 200 pages of stuff to look through. Just let me know if you got any questions. If it's ready, we'll just go ahead and sign it. Oh my gosh. It's so much overload for so many people that they just can't get to it. It's too confusing because, well, wait, this says one thing in one place. It says another thing in another. And they don't get an overview. So what we have is the estate strategy session where we get the answer to the big 4 questions, keep it simple, make sure we're getting the feedback and the information on who they want to do certain things. And then how is the estate allocated and distributed, and put in several layers of contingencies, talk about age limits and things like that. All right. We do that at the strategy session. Next step is the estate summary. We're not going to just send them all of these documents and say, here, read through it. Again, information overload. The estate summary, we walk through section by section. Usually it's only about 10 to 20 pages. And I spend a lot of time covering, here's what the different documents are, here's what they do, and walk through it. And then here's what all the names under the different positions are. Here's the flow of the estate. Here's what happens if this person passes on. Here's the age limits, and it's all walk through. All right. Now we're going to send them the documents and have a document review meeting. And suddenly things are so much easier because they've had that intermediate step of the estate summary to go through, that it becomes a lot easier to go through the documents in whatever depth they're comfortable with. Great. Usually, about 80% of the time, that meeting becomes, all right, I read it, Jeff. There's a lot of legalese. I've just got 1 or 2 questions, or maybe a change or 2, and we go from there. The other 20% of the time, well, there's a reason why we schedule all of our appointments in 1.5 hour increments, just in case. They walk in with 10 pages of notes. What's this Texas and Florida homestead exemption? Can you explain the generation skipping tax? Go over again what's the difference between the A, the B, and the C part of the trust. It's like, all right, look, we'll go through it. The objective is to make sure that at that point, everything has all the questions are answered, everything is updated with any potential changes, and it's done. So then we can go to the next phase, which is signing everything. So we get the documents put together through the estate planning source. It's ordered, it comes in, set the signing. That's all we're doing on that day is signing everything. That's it. Well, why do we do it that way? Why can't we then just proceed to the next step and talk about funding? Look, I've been doing this long enough to realize that even though it may only be half an hour of time for signing everything, everybody is mentally drained. And nothing that we say sticks. And then the next meeting just ends up being having to recap everything that we did at the end of the last meeting rather than actually going on to the next phase, which is the funding meeting. We keep it all in that process so that signing is separate from the funding meeting. I think it's important enough to make sure that we have that full amount of time to talk about all the different assets and what they do. So we have our clients fill out that confidential financial analysis form ahead of time, go account by account, asset by asset, discuss what's the best way to make sure that it gets working in conjunction with the trust and the overall estate plan. So that's the funding meeting. One of the things that we do, which I recommend taking a look at, we actually provide written instructions in the form of a spreadsheet. Transfer ownership of this account into the name of the trust specifically. And then I put, quote, there's the full name of the trust along with the date of it already in there. And I tell my clients, if you're going particularly to a bank, bring your trust, bring the recommendations, plop the whole thing down on their desk and go, here, this is what the attorney said to do. So it's nice and easy and smooth for the clients. And then there's a meeting after that I offer, and I wish more of my clients took me up on it. We call it a family review meeting. And that's where we can bring in whomever they want, walk through the different documents and what they do and open it up for questions. Kind of like that same section in the estate summary where I walk through those different documents and talk about what they do. Now it's for the benefit of whomever they want to bring in. And I typically recommend, look, if we're going to do this, bring at least the first and the second successor trustee, since they're the ones who are going to have to grab the binder and start getting to work if anything happens to both of you. So that's the process. So we've kind of taken that interlude. Let's get back to the rest of it, the other 8 things. Third deadly sin for an estate planning practice, not having an educational presence online that is available to your clients, the general public, or both, and not using it to save time. All right. One of the things, I've written quite a few books. They're available on Amazon.com. I try to keep it as simple and in plain English as possible. But my kind of overriding theory behind writing these books, or you could even say they're booklets, they're smaller, easier reads. If I get the same question more than 3 times in 1 week, and it takes me more than 15 or 20 minutes to explain it, it's better off if I have a book. And that's really where I came across putting together estate planning basics. Talking about the long-term care solution for Medicaid planning. Here's what the different rules are and what they do. So I have all of these educational materials. Having that type of stuff online really helps with my clients and prospective clients getting the general concepts, so that when they come into my office, we're getting right to what their goals are and getting right to the important questions. And I don't have to spend an hour and a half talking about, well, what's the difference between a will and a trust? What's probate? What are the downsides of probate? Look, all that stuff is in the materials that I have. Now, we used to send out a book, but now look, everything's digital and online. I've got my own educational materials on just avoiding probate and estate planning at freetrustcourse.com. Again, that's freetrustcourse.com. So that just goes through all of those basics. I also have the YouTube channel, and the easiest one is youtube.com nc lawyer. And that has a lot more specific items and specific things. So there's a lot of material. I've been putting videos up for quite some time, but having that educational process online, that educational presence has really helped, because not because I'm getting a ton of clients. Oh, I saw the video, I got to work with this guy. No, look, people are doing their due diligence online. So someone gets a recommendation, or they say, oh, I did a Google search, this attorney's near me, and they Google my name, those YouTube videos are going to pop up. And now they're seeing me and they're able to get information for free. And I've had a lot of clients go, yeah, I saw you on YouTube. I saw this specific video. It really resonated with me in my particular situation. But there should also be blogs. And we're getting now to the fourth point, the fourth deadly sin: not having an automated method of trust client follow-up, annual meetings, having an e-newsletter. Something that's really a big thing is making sure that my clients understand that you don't just sign a trust and that's it, it's done. You really need to make sure you're funding your trust as well as keeping on top of it from year to year. People should be coming in for an annual review meeting with the attorney, or at least if in this process, if the advisor is discussing this during their annual meeting or even more frequently, we can make sure we're staying on top of things. One of the stories that I end up telling quite a bit, and this is going back more than a decade, and this was at a point where people were really still taking a lot of money out of ATMs and using cash. Well, a bank that shall remain nameless, but is kind of headquartered in North Carolina, they came up with this brilliant idea of, let's go ahead and charge a $5 a month ATM fee for our clients that have checking accounts that have a debit card that can be used at an ATM. And we won't do any per transaction fees. Well, there were all these people who weren't using the ATM to pull money out. And they're like, you're charging me $5 a month for nothing? And then for like 6 to 8 weeks, people just started pulling their money out of the bank. They were so insulted by this $5 a month fee that they just took everything and went to other banks. And the bank was like, okay, fine. We were kidding. But for that whole next year, my clients who did come in for their annual review meeting, part of what we do is walk through the assets. Is you still have this? Is this still in your trust? We get to those bank accounts. Oh, do you still have your bank accounts at XYZ Bank? Oh, no. Did you hear what they did? Oh, yeah, I heard exactly what they did. Well, we took that money out. We went straight down to this bank and we put our money in there. Well, did you set it up in the name of the trust or your individual names? Oh, we were so upset. I think we set them up in our own names. So this is where that follow-up, that annual review meeting really came into play, and we catch up with that, but making sure there's some automated system going out. The other thing that we do through our e-newsletter, there is one article. I send it out twice a year as the lead article in the newsletter, even though it's exactly the same, and it's about the importance of trust funding. So this way my clients get it. And the other thing from a practice standpoint, by them getting that information over several years, twice a year, the kids can't come back and say, well, you didn't tell them about funding their trust. Those lawsuits are going to start coming. I'm convinced it's going to happen at some point. All right. Number 5, meeting with people without them doing their homework. For me, I mean, I know there are plenty of attorneys and advisors who are happy to talk with people for free. They consider it a valuable amount of time, but look, if they're not doing 3 specific things before they sit down and meet with me for a strategy session, then I know that the stats are there, that it's just wasting a lot of my time. First thing they have to do is they have to read whatever book is appropriate. And usually it's either estate planning basics for, hey, we need to do estate planning, or the long-term care solution if we're talking about potential long-term care and Medicaid planning, either of those. And they have specific questionnaires that need to be filled out and provided back to us before the meeting. So that's the second thing. And now the third thing, they have to actually come to my office and sit down so we can go through things. All right, so what are the stats on this? I mean, why would you do this? Well, look, I didn't used to require it. I used to just sit down with anybody who wanted to talk about estate planning. All right, so because I'm talking about avoiding probate, because I'm talking about concepts other than a last will and testament, which is what all the probate attorneys tell their clients, oh yeah, just go ahead and do a last will and testament. Probate's no big deal because we know they're getting 4 to 10% of that estate on the back end by handling the paperwork that's not necessary. Well, when we've got a revocable living trust, we're trying to avoid probate. Here's the stats before. Almost universally, almost 100%, they needed a second meeting because we spent the first meeting talking about probate. Here's the difference between a will and a trust. Here's what probate actually is. And it was a completely foreign concept of a revocable living trust. Why isn't everybody doing this? I don't get it. Okay, fine. They got to come back a second time. Only 50% actually came back for that second meeting. And then 50% of them do something with us, but only half of the time they did a trust. And usually it was, well, I don't fully understand this trust, so I'm just going to do what everybody else does, which is a will. So for every 8 1.5-hour meetings, we would get a trust. Plus 4 1.5-hour meetings. Okay, now it's 50% after we've instituted those. We need those 3 things. 50% cancel up front, but look, that's fine because they want to go with what's cheapest and what's simplest, and they may go with an attorney to do a will. Sometimes they come back to us, but okay. When they get into my conference room, 85 to 90% are doing something and signing up right there after that first meeting, right there at that first meeting at the end of it. 90% of that time, it's a trust. And it's because they've read through the book. They understand the difference between a will and a trust. And we spent that first meeting focusing on their goals and what they want to accomplish and getting the answers to the big 4 questions about who's doing what and how the estate goes. It's a lot easier. It wastes a lot less time. I almost fired an employee who wanted us to switch back to the old way of doing things. No. All right. So yeah, we want people to do their homework, but there's a reason behind it. And so that's a way that we screen out the clients that aren't really serious, but we're screening in the clients who really are, that we can spend a lot more time working with and help them. So I recommend you as attorneys and advisors, if you're watching this as an attorney or advisor, make sure that you've got your own kind of screening process before meeting with people. And you're probably going to save a lot more time and provide a lot more education to your clients and make your meetings a lot more productive. All right. What's the 6th deadly sin? Meeting initially with only one of a couple for an estate strategy session when you're doing the planning for both. It's almost guaranteed at this point. They can come in. Yeah. My wife couldn't make it or my husband couldn't make it. If we sit down, we walk through everything, go through all the steps, talk about the big 4 questions. Who do you want here? Who do you think your spouse would want here? Go through all of it. Okay. Are you ready? Well, yeah, I'm ready. And walk through the engagement agreement. Time to sign. Well, I really think I need to talk with my spouse first. I can't sign anything and commit to anything without them. And then they try to communicate what I told them. The spouse doesn't understand it. And so we got to have a second meeting. All right. So if we're doing planning for a couple, we're not going to meet with just one of them. if it's, well, and attorneys get this, if people are doing their individual plans and they don't want their spouse involved, well, that's one thing. They're coming in, they're going to sign their own engagement agreement because it's their own plan. All right. Number 7, the 7 deadly sin in the estate planning process: having meetings before the meeting. All right, let me give a story to explain exactly what this is. This has happened several times. We have that process where we walk through, here's the estate strategy session, here's the estate summary section, here's the document review meeting. And every now and then I get clients that want explanations. I've got some corrections. I want this done before we meet. All right. The estate summary meeting. Here are these 7 things that are wrong. I want this, this name needs to be corrected. This needs to happen this way. And I changed my mind on this. I want this changed around. And then go ahead and put that together and send it back to me. No, I just absolutely refuse. Why? Because the purpose of the estate summary meeting is to go through exactly what they just sent to me. The other thing is they've got a whole bunch of questions and they're sending it by email. Now, I can tell you that it takes an awful lot more to put in writing, here's the answer to your question in a lot of detail, to make sure that I'm covering everything. And even then, if it's like, yeah, I think I've covered every possible contingency in your question, suddenly I look at my watch and I'm like, okay, this took 45 minutes to write out this response. They're going to have follow-up questions. If you can just have the discussion and have the back and forth in the meeting, great, it's going to happen. One particular case, the wife just, I'm not coming to another meeting until I know what's going to happen in the meeting. Well, I told you what's going to happen in the meeting. Well, I need these changes done beforehand. Fine, we did the changes. They came into the meeting. Okay, here's this, here. We went over this. You're just wasting our time by making us come in for this meeting. No. So everything happens in the correct order. We stick to that process and we accomplish what we need to in the meetings. And then we have that potential homework in between the meetings to clarify things. All right. Number 8, just go ahead and do the documents. We don't need a meeting. Okay, no, I'm not going to just be a rubber stamp for another professional, an advisor. And this actually happened with the advisor who initially brought me into the estate planning source network many, many years ago. Dropped out of the business for a bit, but I really don't think it was voluntary. And then many, many years later, after he completely dropped off the radar, he leaves me a voicemail. Hey, this is so-and-so. Remember me? Hey, I got a workbook all filled out. I need the trust in 4 days. Can you just take the workbook and put it together? Oh, no. I am not going to just put it together without speaking with the clients. I need to make sure that I'm doing my due diligence on my end to make sure that we're getting the client exactly what they want, not something that was filled out in a workbook that the clients may not have all of the different options on. All right. So now, number 9, this is the big one. I am not going to give out prices ahead of time over the phone unless you just want to be a document salesperson, then you're not going to give out prices because, look, it's not just about selling a document. It's about doing a plan. What I usually tell people is, look, if you need to have your appendix taken out, go to a doctor. What do you need that for? Just go on Amazon and you can buy a scalpel. Do it yourself. It's all about the scalpel, right? No. Look, your estate planning documents are a tool in putting together the estate plan. That's what the attorney and the advisor is there.
In addition to not being a document salesperson, the fact is a lot of times when people are approaching estate planning for the very first time, they really don't know what they need or what the best plan for them is. And that's part of our job as professionals, as estate planners, to make sure that our clients are getting the exact type of package that they need. And it's not just as simple as, oh, are you doing a will or are you doing a trust? In some cases, a complication or another factor may enter into it that really has a couple of things that need to be added to the plan. All right. So just for example, it's very common, and these are the packages. All right, we could do a simple will plan for our clients, and it's a simple will: healthcare power of attorney, durable general power of attorney, nomination and conservator living will. If they've got young kids, appointment or nomination of a guardian, fine. That's one price. Second, we have the trust plan. So yes, avoiding probate is important, and they want to make sure they're doing it the right way. So we're doing a revocable living trust as the core of that plan. And I'll have all those ancillary documents that go along with it. That's the most popular for what my clients mainly need. But then we sometimes get to what I call the trust plus. To the kids, what I say to the clients is this is in-law protection planning. All right, this is where you have a son-in-law or a daughter-in-law and you absolutely positively do not want them to have any access to your inheritance, to the point where you don't even want your child, if you pass on, to be able to take that and then leave it to the spouse in their estate plan. You hate this daughter-in-law or son-in-law so much that you want to make sure they never get a penny of your money, which, okay, great. We're setting up asset management trusts for the kids for the money to filter in. We're also doing IRA trusts so that the IRAs go in IRA trust, get the full stretch, but protect the money, and then 10 years later can combine with the asset management trust. So now for that whole children's lifetime, that money is held by a trustee and then has to go to the grandkids after. Okay, fantastic. That's definitely a different price. And then we sometimes, only occasionally, we get the full bloom. We need irrevocable trusts. We need lawsuit protection. And okay, we've got package prices for all of that. Occasionally it's like, well, okay, we've got one special needs child out of 3. They're adults. We need to protect their benefits. And the grandparents are leaving something to them. Oh, okay. That particular child may just get an IRA trust added on to make sure their assets are protected, and then 10 years later can get combined with whatever share you're leaving them in the revocable trust. The grandparents have that trust now for a special needs trust to drop that money into. So there's just a couple of additions. You don't get that over the phone. You have to sit down with your clients and understand exactly what they need, what goals they have, and then what tools are needed for you to put together the plan. Now, here's what happens. And this was at least half the time when my staff, against my instructions, just, okay, fine, you're beating me up so much about the prices. Here's what the different packages are. Here's what it costs for will. Here's what it costs for trust. Here's what the trust plus costs. We sit down, they need more than the trust plan. They need a little bit more. The only number they remember is what was for a simple will. So they quoted that package. 50% of the time, the clients would just get so upset. They're not going to do anything. But you said it was only going to be this, or your staff said it was only going to be this. It's like walking onto a car lot and saying, what's the least expensive car you've got on the lot? And well, we've got this 1996 Honda Accord with 300,000 miles on it. And on the top end, we've got this brand new Mercedes convertible for 175,000. The Honda Accord's only 1,000. They're going to want the Mercedes for the 1,000, 50% of the time. So that's why we just don't do it. Until we know exactly what's going to be the best plan, we can't quote a price. But the way we do it is we do have, after that strategy session, we do have a flat rate price that we give to the clients. So, and the way I explain this to my clients is, yeah, we're giving you a flat rate so that We're not charging you by the hour so that you will feel free to ask as many questions as you want. So this is another thing that I've seen when you charge by the hour. A lot of time clients have questions, but they don't want to ask them because it's adding to the bill. And so you could give them the best estate plan in the world for them, but they're still going to be upset because they don't understand it. So that's why some cases we spend a lot more time. Sometimes it's a lot less and a lot easier. But with that flat rate pricing, it averages out. But we do not give those prices over the phone.
All right. Number 10, not having some kind of signed engagement agreement, because look, people's memories become really weird, especially over time. If you have a signed engagement agreement that goes through, here's what happens in this process, here's your understanding of it, here's exactly what we're going to do, here's what we're not going to do. If there's something that's optional, here's what that optional thing is, and here's what the cost is. And there's a note page where we can adjust things and add things or deviate things or change prices. Look, it's all good, but it's all in writing and it's signed by the clients before we're going to begin work. I have these two clients that actually changed my pricing policy because when we had a total cost, we were at that point doing a flat rate fee. Here's what it costs to do this, and that's it. But it's going to be paid in monthly increments until it's paid off. And so just to throw out a number, and it was a long time ago, oh, it's $3,000 and we'll give you the first 1,000 now. And then it's supposed to be $1,000 the next month, and then $1,000 after that paid up. We got the first 1,000 to get started, did all the work. 5 months later, like, you haven't made your payment, and the credit card you gave me doesn't work. Well, we got rid of that. We just prefer you bill us. Okay. And we kept billing them, and they kept finding a reason not to pay. And then for the last payment, no word of a lie, this was 15 months after we started. Well, we still have outstanding questions, and we're not going to give you the last $1,000 until those questions are answered. And they just made such a big deal out of everything that it took us, like I said, 15 months to get paid. We don't do that anymore. Our pricing policy is, look, either it's going to be, if you're doing a check, it's going to be upfront, full amount. We do not bill for those clients at the initial estate process. Or if you want to spread the payments out, we are using a credit card, and that credit card better be good, because otherwise we stop work right there. And it served me very well. Well, what happened? These clients came back many years later. They wanted changes, and we expect you to do this for free. Oh, no. That engagement agreement made it very clear that here's what happens. This is what we're doing. And there was nothing in there that said we were going to do updates for free. And so I said, here's what it is. It's per hour. If you want this change done, then this is how we're going to do it. And then after that, I was like, well, I got some extra questions. Like, well, okay, well, we just need to make sure that we've got your billing right. Shouldn't that be included for free? No, it's not. Well, when they had to pay by the hour for that extra work, they just drifted off. Hopefully they found the answer to whatever the general questions are, but they probably got it through the materials that I put out online. All right, so that's the 10 big things. Let's have Okay, sorry. Shalene, if you can kind of take that down. I'm going to open it for questions. I just realized we're almost at 40 minutes, and I put a whole bunch of bonus things in there. All right, that's something that I can communicate to you at some other point. I just want to make sure we've got enough time for any kind of questions that you're going to have. So please go ahead and throw out whatever questions you've got. The chat is there, and it's live. We'll see if anything pops up. I can start with one of these kind of bonus things that I put. One of the things that I tell my staff never to ever do is to call our estate strategy session or the kind of 30-minute call that we put in ahead of time. Do not call it a free initial consultation. That just kind of has a connotation of this is a sales pitch of some sort. And I've just gotten a lot of negative reactions. So I call it a discovery call for that 30-minute call. Or when we're sitting down for the hour and a half, it's an estate strategy session. All right. Not seeing anything else in the chat. I can throw out another one. Oh, yeah. Not putting a timetable on we'll think about it clients. So at the end of the estate strategy session, I'm walking through the engagement agreement no matter what. Here's the cost. Here's the price. If you're good with this, go ahead and take the engagement agreement with you because you're not ready to sign it now. And here's how you can handle payment. I had someone come back. It was about 2 years ago. And I walked through everything. They looked familiar, but I didn't really have any, I didn't have any plan for them. And so I said, here's everything. Here's what the cost is going to be. And they kind of flipped out and said, you said it was only going to be this. Oh, when did I say that? When you did that seminar at the library. I haven't done a seminar at a library in like 12, 13 years. Oh, yeah, that's the one. Okay, I obviously wasn't going to give them that same price. It was all that time later. But now if they're doing an I'll think about it, I still walk through the engagement agreement, but now I write in that this price is good until, and I'm typically giving them 6 months. I know it's kind of a sales technique to, oh, you've got 10 days to come forward and do this. I don't do that, but I'm not saying you shouldn't, but I give it 6 months because the prices could change at that point. All right. I am not seeing any questions in the chat. Shalene, anything you want to add?
I just want to thank everybody who joined us, and thank you for speaking today, Jeff.
Yeah, my pleasure. Let me make one more comment. Make sure that you are subscribed to the channel on YouTube because that really does help out the estate planning source. And look, if you want to jump over to mine, it's youtube.com/NC Lawyer. Got lots of great stuff. If there's videos on there that are going to help you explain things to your clients, then please go ahead and use it. I'm happy for you to steal my stuff. All right. Well, thank you very much. As I always tell my clients, stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day. Hope to see you at the Advanced Institute.